Students, today I shall discuss transfer of property law. This is a law which is a part of legal environment of business course. So in this lecture, I am going to discuss the following topics: meaning of transfer of property and meaning of property, important points of view regarding the passing of ownership, transfer of property in specific or ascertained goods, transfer of property in unascertained goods, and transfer of title by non-owner. Transfer of Property Act 1882 came into force on 1st July 1882. There are two main objects of this law, such as regulate transfer of property between living persons and complete the code of contract law for immovable property. Act does not purport to be exhaustive. It does not cover each and every aspect of transfer of property. Dear students, first I will explain what is property and then I will discuss what is transfer of property. Now, what is property according to law? The Transfer of Property Act 1882 TPA does not define the word property. Many other statutes define the word property on the basis of their objects. For example, Sale of Goods Act 1930. Property means the general property in goods and not merely a special property. Wealth Tax Act 1957, Section 4 explanation C, the expression property includes any interest in property, movable or immovable, the proceeds of sale thereof, and any money or investment for the time being representing the proceeds of sale thereof, and where the property is converted into any other property by any method such other property. And Gift Tax Act 1958, Section 2, property includes any interest in property, movable or immovable. Now we shall discuss what is transfer of property. Transfer of property in goods means the transfer of ownership of goods from seller to buyer. According to Transfer of Property Act 1882, transfer of property means an act by which a person conveys property to one or more persons. The act of transfer may be done in the present or for the future. The person may include an individual, company, or association or body of individuals, and any kind of property may be transferred, including the transfer of immovable property. The precise moment of time when the ownership of the goods is transferred from seller to buyer is important to buyer. So, in this transfer of property in goods situation, we shall identify some issues which are important to this transfer. The issues or point of views are: risk prima facie passes with property, action against third party, suit for price, and insolvency of the seller or the buyer. The first point is risk prima facie passes from seller to buyer. That means when goods are transferred or goods ownership is transferred from seller to buyer, then risk of destroying the goods also is transferred from seller to buyer. Therefore, if after the contract the goods are destroyed or damaged, the question who is to bear the loss is to be decided not on the basis of possession of the goods, but on the basis of ownership of the goods. Here is an example. A buys goods from B and property has passed to him, but the goods remain in B's warehouse. Before delivery of goods to A, there is a fire in B's warehouse and all the goods are destroyed. In this case, A must bear the loss and pay the price of goods to B if he has not paid it so far. However, there are exceptions of this rule, such as A contracted to purchase 30 tons of apple juice from B. B crushed the apples and filled 30 tons of juice in casks and kept them ready for delivery. After a few casks had been delivered, A refused to take further deliveries. The juice became putrid and had to be thrown away. It was held that although the property in good was still with B, yet the loss had to be borne by A. Action against third parties. If, after the contract of sale, the goods have been damaged by a third party, it is only the person in whom the property rests who can take action against the wrongdoer. Another point is suit for price. Generally speaking, the seller can only sue for the price if the property in goods has passed to the buyer. Another point is insolvency of the seller. The answer to the question whether the official receiver or assignee can take over the goods or not shall depend upon whether the property in goods was with the party who has become insolvent. If the seller becomes insolvent before giving delivery of the goods, but the property ownership in goods has already passed to the buyer, the official receiver can have no claim against the goods. Dear students, now we shall discuss transfer of property in ascertained goods. In discussing this point, we are going to discuss some specific issues related to this main topic. Transfer of property in a specific ascertained goods when goods are in deliverable state, when goods have to be put into a deliverable state, when the goods have to be measured to ascertain the price, and or when goods are delivered on approval. We shall see the detail. When goods are in a deliverable state for specific or ascertained goods, the property in the goods passes to the buyer as soon as the contract is made, and it is immaterial whether the time of payment of the price or the time of delivery of the goods or both are postponed. Here is an example. A buys a bicycle for Taka 3000 on a month's credit and asks the shopkeeper to send it to his house. The shopkeeper agrees to do so. The bicycle immediately becomes the property of A. When goods have to be put into deliverable state for specific or ascertained goods, the property does not pass until the seller does something to the goods for the purpose of putting them into a deliverable state. Something includes packing the goods, loading them on rail or ship, filling them in containers, or polishing them to give a finished shape. When goods have to be measured to ascertain the price for certain or specific goods. In this case, where the seller is bound to weight, measure, test, or do some extra act or thing to ascertain the price of the goods, the property does not pass until such act or thing is done and the buyer has notice thereof. When goods are deliverable on approval of ascertained or specific goods, the property passes to the buyer when he signifies his approval or acceptance to the seller, or does any other act adopting the transaction, for example, resell the goods. And if he does not signify his approval or acceptance to the seller, but retains the goods without giving notice of the rejection beyond a reasonable time. For example, A delivered a horse to B on the terms of sale or return within 8 days. The horse died on the third day without any fault on the part of B. It was held that A was to bear the loss as the horse was still his property when it perished. Dear students, now I shall discuss transfer of property in unascertained or future goods. In unascertained or future goods, transfer of ownership will not occur, or ownership will not be transferred from seller to buyer until or unless it is ascertained. For unascertained or future goods, there are some essential elements which are important in relation to ascertained or appropriation. Now we shall see those essential elements. The appropriation must be of goods answering the contract description both as to quality and quantity. The appropriation must be intentional and it must not be due to mere accident and mistake. The appropriation must be made either by the seller with the assent of the buyer or by the buyer with the assent of the seller. And the appropriation must be unconditional. What will be the legal explanation for delivery to carrier for the unascertained or future goods? In this case, a seller is deemed to have unconditionally appropriated the goods to the contract where he delivers the goods to a carrier or other bailee for the purpose of transmission to the buyer and does not reserve the right of disposal. Therefore, delivery to a carrier without reserving the right of disposal is a delivery to the buyer and the property passes at once at the time of delivery to the carrier. Now, what is the legal explanation of reservation of right of disposal? Now we shall see the legal explanation of this reservation of right of disposal. Reservation of right of disposal means reserving a right to dispose of the goods until certain conditions are fulfilled. When the seller reserves such a right, the property in goods does not pass until those conditions are fulfilled. Dear students, now we shall discuss the rule of transfer of title on sale. A seller cannot give the better title of in goods what he himself has. If the title of the seller is defective, the buyer's title will also be subject to the same defect. A buyer cannot get a good title to the goods unless he purchases the goods from a person who is the owner thereof or who sells them under the authority or with the consent of the owner. However, there are some situations where a non-owner also can transfer a better title to the buyer. We shall see now those situations. The situations are where transfer of title by non-owners, that means non-owners can transfer a better title of the goods, such as an unauthorized sale by a mercantile agent, transfer of title by a stopel, sale by a joint owner, sale by person in possession under voidable contract, sale by seller in possession after sale, sale by buyer in possession after agreement to buy, and resale by an unpaid seller. Authorized sale by a mercantile agent. That means an agent is not the owner of the goods, but he or she can transfer the ownership to the buyer. Let us see an example. F entrusted his car to a mercantile agent for sale at a stated price and not below that. The agent sold it to S, a bona fide purchaser, below the reserve price and misappropriated the proceeds. S resold the car to K, the defendant. It was held that S obtained a good title to the car from the mercantile agent and he conveyed a good title to K, and therefore F was not entitled to recover the car from K. The second point is transfer of title by estoppel. Now, what is the meaning of estoppel? Estoppel means that a person who, by his conduct or words, leads another to believe that certain state of affairs existed would be stopped from denying later on that such a state of affairs did not exist. The basis of estoppel is that it would be unfair or unjust to allow a party to depart from a particular state of affairs which he has permitted another person to believe to be true. Here is an example of transfer of title by estoppel. Mr. M, the owner of a wagon, allowed one of his employees K to have his name painted on it. M did so for the purpose of including the public to believe that the wagon belonged to K. C purchased the wagon from K in good faith. C acquires a good title as M is stopped from denying K's authority to sell. In case of sale by a joint owner, for example, A, B and C are three brothers. They own a cow in common. B and C entrust the work of looking after the cow to A and leave the cow in A's possession. A sells the cow to D. D purchases bona fide for value. D gets a good title. Sale by person in possession under voidable contract. For example, A by misrepresentation induces B to sell and deliver to him a cow. A sells the cow to C before B has rescinded or rejected the contract. C purchases the cow in good faith and without notice of the seller's defective title. Therefore, C acquires a good title. Sale by seller in possession after sale, where a seller, after having sold the goods, continues to be in possession of the goods and again sells them, will convey a good title to the buyer in good faith and without notice of the previous sale. Sale by buyer in possession after agreement to buy, where a buyer has agreed to buy the goods and has obtained possession of the same, resells the goods either by himself or through a mercantile agent, he will convey a good title to the buyer provided the person acts in good faith and without notice of any lien. Resale by an unpaid seller, where an unpaid seller who has exercised his right of lien or stoppage in transit resells the goods. The subsequent buyer acquires a good title thereto as against the original buyer, even though the resale may not be justified in the circumstances. There are some exceptions under other acts. Other acts also contain some provisions under which a non-owner may pass to the buyer a better title than he himself has. For example, sale by finder of lost goods under certain circumstances, sale by pony or plesy under certain circumstances, sale by official reservoir or assignee in case of insolvency of an individual or liquidator of companies, and under the Negotiable Instruments Act, a holder in due course gets a better title than what his endorser had. Therefore, non-owner in the above cases can transfer a better title than he himself has. Dear students, we discussed what is property, what is transfer of property. We also discussed transfer of property of ascertained goods, transfer of property of unascertained or future goods. We also discussed transfer of title by an owner and transfer of title of the goods by non-owners. Dear students, I hope that the discussions we made today will be useful for you to understand the transfer of property law. Thank you.